Just give me 1 second. Sorry, we've updated things. Okay, we can go ahead and get started.
Okay, good evening, everyone. Welcome. I am Liza Hirsch. I'm an attorney at MAC, and I'm here as well with Julia Landau, who's also an attorney at MAC, who you have come to know well if you've been attending all of these chats. I'm also joined by Lilia Malikshi and Joanne Pino, who will be coordinating logistics tonight. And we just, wanted to acknowledge that this is, I think, month 14 of the pandemic, and if you can believe that, and it's the end of another pandemic school year, and we know these months have been incredibly challenging for many of you and your children, and so we hope that tonight we'll be able to provide some practical information and tips on navigating the special education process during the pandemic and as you think toward the recovery. And then tonight we are specifically going to be going over the PRS problem resolution system complaint process, which is through the State Department of Education. And then we also are going to leave quite a bit of time for question and answers, both about the PRS process, but also to answer questions that you have more generally about the special education process during COVID-19. So I am going to turn it over to Lilia to go over some logistics, and then we will get started.
Thanks, Liza, and thank you everyone for joining us tonight. Welcome back to all of our regulars. We're excited to now offer live transcription and captioning for our chats. You can click the live transcription button if you're joining us on Zoom on your Zoom menu to turn that feature on or off. Tonight we will pause throughout and leave plenty of time for questions at the end of the presentation. Questions can be submitted at any point. Please try to keep your questions brief to allow us to get to as many people as we can. To submit a question, please click the Q&A button on the menu on your screen. If you're joining us on Facebook Live, please submit your question as a comment under the live stream. If you see someone else's question that you'd like us to answer, please give it a like. The chat feature is going to be turned off for participants, but please keep an eye on the chat box in Zoom and in the comment section on Facebook for resources that we'll share throughout the presentation. Thank you.
Okay. Okay, so first I'm going to start, as I said, with going over the problem resolution system, complaint system, which shorthand is PRS. Many of you may have heard the term PRS, and that's how I'll be referring to it going forward. The PRS system is most useful for handling instances of non-compliance, so situations in which the school district is not following the student's IEP, for example, or otherwise not following the law. And PRS complaints can be filed by anyone, basically. They can be filed by parents, students, advocates, educators, or other third parties. And the complaint is actually fairly simple to complete and submit. And I'm not sure many parents are aware of this, but there is a complaint that's accessible online, and it's an online form that is relatively short and very simple and straightforward, where you enter basically demographic information and then answer a few brief questions about the non-compliance. And then you can actually sign electronically and submit the form online. You can do that in either English or Spanish. And then there are forms available in 8 additional languages, which you would need to print out and complete by hand and then submit. But the complaint form online, I think, is really useful because you can do it very efficiently and just relatively easily. So really encourage people to take advantage of that. I wanted to first give a couple of examples, general examples of the types of situations in which a parent may want to file a PRS complaint related to non-compliance. So one example that I think is fairly common is if the school did not follow required evaluation timelines for conducting an evaluation. So as many of you know, the school district has 30 school days to conduct an evaluation from the time that the parent submits the signed evaluation consent form, and the school district has 45 school days to convene a team meeting to discuss the results of those evaluations. And so if the school district has not followed those timelines, that's an example of non-compliance, and a parent could file a PRS complaint. I would encourage, parents to first try to address the issue with the school district directly, just because of, making an effort to maintain a good relationship with the school district. And certainly if it's just 1 or 2 days past the timelines, I wouldn't recommend filing a PRS complaint in those cases. I would just recommend contacting the district. But if it's like a month or 2 months or 6 months past the evaluation timelines, and you've raised it with the district, the issue with the district, that could be a good example in which it may make sense to file a PRS complaint. Other examples, a very common example of non-compliance in which it may be appropriate to file a PRS complaint is when the school did not provide a service on your child's IEP. So if the service is written into the IEP and that IEP is signed and in effect, and the school district is not implementing that service, then that's a violation of the law, that's non-compliance, and that's a reason that you could file a PRS complaint. So for example, if the IEP states that your child is entitled to speech therapy 2 times 30 a week, and the school district is only delivering speech therapy 1 times 30 a week, that's an example of non-compliance, and you could file a PRS complaint. Another example is if the IEP states clearly that your child needs a one-to-one aid, but the school district is either not delivering that aid at all, or perhaps the aide or paraprofessional is responsible for 3 or 4 or 5 students, and the IEP states it's supposed to be a one-to-one aid. That would be another example of non-compliance. Or if the IEP states that your child should be receiving special education instruction all day, and the district, particularly in the COVID context, is not providing that instruction, that would be a third example. And again, with all of these examples, I would really encourage you to first try to address them with the school district directly and through the IEP team process. But if you've not been successful through those avenues, you do have the option of filing a PRS complaint to try to resolve the issue. So all of the examples I just gave could be relevant during the pandemic. And then these are a few more specific examples that are related to COVID-19 specifically. So, and examples of situations in which you could consider filing a PRS complaint. So first, if your child has significant and complex needs, but was not provided in-person instruction when school districts were closed. So for a long period of time since the beginning of the pandemic, even when school districts were closed, the State Department of Education was very clear that students with significant and complex needs should still be provided in-person instruction. And there's a list of criteria for who qualifies as having significant and complex needs. But one of the criteria on that list is basically not being able to access remote instruction. So if your child, for example, had substantial difficulty, really could not access remote instruction, then they meet the definition of significant and complex needs. And if the school district did not provide in-person instruction, then that could be a reason to file a complaint. And as long as it's within, you have to file the complaint within 1 year of the non-compliance. So as long as it's within that year, you could file a complaint and, for example, seek compensatory services for some of that missed in-person instruction. Another example is if your child, and we've seen some of these examples, we've heard about some of these examples, is if your child has a social skills group on his or her IEP, and that service was just not delivered during COVID. The school district just said, we can't do it, there's no way to do it remotely, and so they didn't even make an effort. They didn't try to convene a social skills group remotely, and they just didn't deliver the service. That's an example of non-compliance, and a PRS complaint could be filed. Another example is if the IEP lists reading instruction 5 times 45 minutes per week, for example, and that instruction was delivered remotely, but your child really was not able to access it. They, say they just were running around during every reading session, running around the house. They just wouldn't sit. They really just couldn't access the service and instruction. then that could also be considered non-compliance because the school is not delivering the service in a way that was accessible to your child. And then finally, if the school has not yet determined the need for compensatory services from last school year, or even from the beginning of this school year, for students with significant and complex needs, school districts should have determined whether your child needs compensatory services by December 15th of last year, of 2020, for the need, to assess the need for compensatory services arising from last school year. So if the team has not convened, and if your child has significant and complex needs and the IEP team has not convened to discuss whether your child needs compensatory services stemming from services that were not delivered last school year and ways in which your child has not made progress or has regressed, then that's a possible reason to file a PRS complaint, just saying that the school district has not even convened to address the issue of compensatory services. And this school year as well, school districts should be starting the process of addressing the need for compensatory services for students. So if that has not been happening, you could file a PRS complaint. Again, I would first recommend trying to work with the district directly to address compensatory services, request a team meeting to address compensatory services, and if all of that is unsuccessful, you could turn to the complaint process. So a few tips for filing when you are completing the online complaint form, or if you choose to print out the form and submit it, there are several fields that you complete. You want to state very clearly what you believe the non-compliance is. So for example, the service that was not delivered or the service that your child could not access. So you want to state very clearly, my child's IEP states 2 times 30 minutes a week of speech therapy. For the past 6 months, list the dates. The school district has only delivered 1 times 30 minutes a week of speech therapy, stating that they don't have speech therapists available, or whatever the case may be. So you've stated very clearly what the non-compliance is. If your child is has been having difficulty accessing remote instruction, again, you want to provide very specific examples of in what ways has it been difficult to access remote instruction? Has it been, behavioral challenges? Has your child had their head on the desk the whole time, hiding under the table, running around the house, just not processing, the instruction for some reason? You want to be as specific as you can and include those examples. And then you also want to include examples of lost skills, regression, or lack of progress. And this has been, we've been hearing that there's been some confusion about this, that many districts are saying that students are only eligible for COVID-19 compensatory services if they've demonstrated regression or if they've actually lost skills, but that's not true, because it could also be in cases in which the student just has failed to make progress, has kind of been at a standstill and not made progress in skills. So you want to provide specific examples around that. Include any documentation or evidence that you have. For example, you could submit photos. If you have photos of your child kind of not being able to focus or engage with remote learning, the videos of your child. Some parents have taken videos, emails that you've sent to the school, or other kinds of evidence that you've collected. And then you really want to include in the complaint specific asks of what you think will help to address the problem. If it's a case in which you think your child should receive COVID-19 compensatory services, it would be helpful for you to state what you think will make your child whole for whatever services they missed and for the lack of progress that they made or the skills that they lost. So you really want to try to think hard about what you think will really help your child and include that in the complaint itself. This is the PRS process. This is basically what happens when you file a complaint. As I mentioned, you do need to file the complaint within 12 months, within a year of whatever the non-compliance was. You submit the complaint. You can submit it online or send in the form. You're supposed to also send a copy to the school district at the same time that you send it to DESE, the State Department of Education. DESE receives the complaint and then very quickly requests the school district's response, which is called the local report. And the school district then submits the local report to DESE and also provides a copy to the parent. And again, the local report is basically the school district's response to whatever is stated in the complaint. And then the parent does have the opportunity to respond to the local report, but this is really an opportunity that I think you really have to ask for. It's not automatically going to be provided in every case. So I would recommend, a suggestion I have is to always ask for the opportunity to respond to the local report and whatever it is that the school district said in their response. And you can just ask the PRS officer who's handling the case whether it's possible for you to respond to that local report. And then within 60 days of the original complaint, of the date that the complaint was received by DESE, DESE, again, State Department of Ed issues what's called a letter of finding, which is basically a decision letter in which it issues a decision about whether there was a legal violation, and if so, orders the school district to take certain corrective actions to address whatever the non-compliance was. So again, we've been over this several times, but you can file the PRS complaint online. That's the link right there to the PRS complaint system. It's a very surprisingly simple and accessible form, and it doesn't take that long to complete. Or you can also print out the form to scan, fax, or mail to PRS department. I've included there the phone number for the PRS office. You cannot file a complaint by calling the PRS office, but you can call to ask questions about what constitutes a non-compliance. You can ask them questions about what's legal and what's not legal. You can ask for whether they would advise you to submit a complaint in this kind of situation. You could call just to ask kind of clarifying questions. But you could also call our helpline if you're looking to answers to those kinds of questions, and we could help walk you through it. And then finally here, I've included a link to a sample PRS complaint that was developed by one of our sister organizations, EdLaw, which I think is a great sample, which you could take a look at. And we also will be putting together our own sample PRS complaint specifically related to COVID-19 compensatory services. And that should be up by next week. So I think we're planning to actually get that out to this group early next week by email. We'll send it out to you all. So that is the end of my presentation on the PRS system. I don't know, Julia, if you had anything you wanted to add, or else we can transition to questions and answers.
No, I thought that was great. I have nothing to add. Thank you.
And again, any questions either related to the PRS process and also, broader than that, if you have questions related to special education generally during this time and your child's situation or barriers you've been running into, feel free to include those as well.
Thank you. All right, we've got a lot of good questions coming in. Before we get started, I'm just going to point everybody to the link to the survey that I just posted in the chat and in the comments on Facebook. If you could just take a moment to click that link and save it. It's an optional survey, but it does help us improve our chat series, so we hope you'll fill it out for us. Without further ado, our first question is, who is responsible for compensatory services if you've changed schools after the services were missed? Is it the school that didn't provide the services that the child's no longer at, or the school that you've now moved to?
Do you want me to go, Liza? That's a great question. The State Department of Ed gave some guidance last spring about this when they were talking about the compensatory services for last school year. And what they suggested or are advising districts and parents is, if you're moved to your new district should convene the IEP meeting to determine whether or not your child requires compensatory services. However, for the period, if the compensatory services are for the period when your child was in the old school district, then the old school district's responsible for paying for the services, and they're encouraging the old school district to make some financial arrangement with the new district so your child could receive those compensatory services through the new district. So that's in their state guidance. I don't know if we can get our hands on it in time to put in the link, but that's basically what the state has advised. Do you have anything to add to that, Liza?
No, that sounds right to me.
Our next question is, my child is in a residential placement paid for by the school district. Can the district provide me with assistance to visit my child? I'm unable to drive for medical reasons, and I haven't been able to see my son in over a year due to lack of transportation and a domestic violence situation.
That's a great question. I don't necessarily know the answer to it. I'm not aware of a situation where the school district has necessarily provided that, but I think it would be a fair question to raise at your IEP team meeting, because if your child has to be in a residential placement, and if you can make the argument that your ability to see your child is going to be important in terms of your child getting the free and appropriate education they need in terms of learning their skills or generalizing their skills, I think you could try to make that argument. I'm not quite aware of where the school districts have done that, but other people who are here may have experience where the school districts have agreed to do that. Liza, do you have anything to add?
No, yeah, I think that's a creative way to frame it.
But again, you've got a lot of knowledgeable participants here on this chat. So if people can share information about how you may have navigated something like that to share with this parent. And again, we could do a little more digging if you wanted to call our helpline. Just a really good question. I don't know off the top of my head.
I'll share also a link to our Facebook group, which is another good place for people to come together and share some solutions. Our next question is on, you mentioned, this was on one of your slides, Liza, instances when you might file. Can you expand a little bit more on significant and complex in terms of diagnosis? What you mean by that?
Yeah, so significant and complex needs is basically you could fall into one of a list of different criteria in order to be considered a student with significant and complex needs. And one of those criteria, as I mentioned, is that the student could not engage in remote learning due to their disability. The other is if they've been identified as high needs on what's called the PL3 form. So if you happen to know that your child has been designated as high needs according to that form, that would be another way to qualify as having significant and complex needs. And the other reasons are if your child uses AAC, augmentative and alternative communication device, if your child is homeless, in foster or congregate care, or is an English learner. So those are I believe the criteria to qualify, and that your child does not need to be all of those, but just one of those. Did I miss anything, Julia?
No, that sounds great. And those are the high need students are the students that the Department of Ed has said that are more likely to need compensatory services for last year. But any child, the state has consistently said that all students with disabilities, districts should do everything they can to get not just high need students, but all students with disabilities in-person options, starting over, the 14 months ago. And regardless of the complexity of the disability or whether the student needs to be at home or at school, they still have to have their IEP fully implemented. So that's all kind of relevant in terms of whether or not, you may, if you can't work things out with the district, whether or not you need to file a complaint. So it's not limited to students who have the more significant and complex needs, just in case there's some confusion around that.
Right, school districts should be prioritizing determination around compensatory services, I think, for that population, but they should also be convening IEP team meetings or otherwise determining the need for compensatory services for all students. And parents, if the school district is not initiating that, parents can go ahead and, you know, ask to convene an IEP team meeting to determine the need for compensatory services, or ask to, you know, otherwise address that need.
To add further confusion to this, there's so much confusion around all this, but there's what a lot of the families we're talking to are still trying to get the IEP teams to determine whether their child needs compensatory services for last school year. And at the same time, we're into May of this school year. And so there's some different guidance from the state around whether, first of all, any child who's had difficulty getting their IEP implemented has the right to ask for an IEP meeting and see whether or not they need compensatory services for this school year. But the state has also emphasized that it's likely that certain students from this current school year are going to need compensatory services. And they've focused on any students with disabilities in districts that have been fully remote for 3 or more months during this current school year are potentially more likely to need compensatory services, and IEP team meetings need to be convened. Students who've been chronically absent, and like Liza said, any students who've had difficulty accessing remote learning because of their disability. So it is really confusing we found for families, for IEP team leaders, for special ed administrators to kind of think about, you have 2 school years where students may need compensatory services.
Yeah, and the last thing I'll add on that is confusing. And the last thing I'll add is just that the need for compensatory services either related to last school year or this school year could be raised in any IEP team meeting. So you could be having an IEP team meeting, like an annual review meeting, and you could raise the issue. You could be having an IEP team meeting that the school district has scheduled to discuss compensatory services arising out of last school year. And you could say, well, but I also want to address compensatory services related to this school year, or I want to schedule another meeting to talk about that. So there isn't any special IEP meeting. It could be any IEP team meeting that you raise these issues.
That's a really good point.
Next question, is it public record to see somewhere how many complaints have been filed against a district and how many instances were found in non-compliance?
What was that? Good really question. A question from you, Lillian? The reason we're laughing is because soon to be released, coming to movie theaters new in your community. The Mass Advocates for Children, we made a public records request. We asked the state to give us copies of the letters of finding that have been issued since the pandemic, since COVID. And under the law, they do have to provide that kind of public information as long as they redact and remove all the confidential information. And so Lilia has been putting together a website that we are hoping to launch no later than 2 weeks, where you'll be able to search for letters of finding that have been issued that are COVID related by your topic, you know, like IEP implementation or failure to comply with timelines, or by school district. So I do have to, they're very blacked out because they're very careful to remove any information so that somebody reading it might be able to figure out who the student is, but you can still see the kinds of issues and the kind of corrective action that's been required in different instances. So stay tuned, and thank you for the question.
Yeah, and so that'll be ready within the next couple of weeks, and we'll send an email out to all of you and have that on our social media as well when it's ready. So stay tuned. Next question is, if the school district was in the wrong and then gets the report from PRS and makes changes before returning their report to PRS, are they still found in non-compliance since they were definitely in the wrong before the complaint?
Having read all these letters of finding, I can tell you what I've seen in them, which is generally, it can be different from, you know, one investigator to another, but generally what I've been reading is that the letter of finding will say that the district was out of compliance, but that they've fixed it. you know, that they've notified the parent that they've done X, or they've invited the parent to a team meeting and agreed to do Y. So at least the ones that I've been reading, they still do make the finding, but they will definitely acknowledge that there's, you know, no corrective action or no corrective action required in terms of a particular issue because it's been fixed.
Yeah, and in my experience as well, that PRS will still issue a letter of finding and still find the non-compliance, but then, as Julie said, just indicate that it's been addressed. But they won't just, ignore or close the case. They will still issue the letter of finding.
I also have to say, and I assume people know this, but just because a complaint is filed, it doesn't mean that it's just like a judge doesn't always get it right. The state doesn't necessarily always get it right. There are definitely families who file a complaint and they're very frustrated because non-compliance is not found, or they don't get the kind of services they think their child needs. So I think what Liza was emphasizing is really important. I think the more specific information you can give to the state when you file the complaint, or after you review the local report, if you contact the state and give them more information, then it's more likely they've got what they need to find non-compliance.
Yeah, and related to that, I would really encourage, once you file the complaint, there's a PRS specialist who's assigned to the case. And I would really encourage you to be in close communication with that person. There's nothing that says that you can't. So you can call that person, you can talk with that person, you can provide additional information to that person, you can make sure that they fully understood what you wrote in the complaint. If they have questions, they can ask you. And I think it can be very helpful to just continue the advocacy, even once you've submitted the complaint, to make sure that the PRS specialist is fully understanding what the issues were.
Thank you. I think we have a few different people wondering this next question. What is considered a reasonable ask? So for example, if a child was due 5 times 30 reading, but was offered no services during the shutdown, 63 school days, what would DESE consider a solution? Would it be a certain number of hours of private tutoring?
Again, really good question. The state has made it really clear that it's not necessarily going to be hour per hour, which I think this person asking at this question is, it might be, it might not be. It really is going to depend not just on the amount of services that weren't provided, but what the impact was on the student. Did the student regress? To what degree did they not make progress? I think the idea is to make the student whole. So it's going to be having to look at both the factors of what services weren't being provided, and then what you can show the impact was on your child. In a lot of the letters of the findings that the state's issued, what they will sometimes order is that the district and the parent have a team meeting to discuss compensatory services. Then if they can't resolve it, often the state will tell the district and the parent to tell the state what they think, what this parent is asking is a reasonable ask, and then the state will decide. They would prefer for the team to figure it out together. So one thing that the families that are asking this, what I might suggest is that if you have a pediatrician or you have any other outside people who are providing services who might help you figure out what is going to be required to make your child whole, that might give you a better sense of what to ask for, and also give the state some sense that you've got something to back it up. But it's not a perfect, even when these cases around, not during the pandemic, but cases are decided by judges around compensatory services, that's basically, they have to understand what the child was deprived of, what the impact was on them. They sometimes might listen to some experts, and it's not a perfect science. But the idea is to try to make put the child in the place they would have been if they hadn't been deprived of the services they need. Liza, do you have anything to add to that?
No, I think that really covered it.
Thank you. I really like this question. Can we file a PRS as a group since the same special education teacher affected us all similarly? So in this case, the teacher did not show up for sessions. Can you file as a group?
Yeah, I'm aware that, Liza, I don't know what your experience has been, but I am aware that PACs have filed sometimes, or class, individual, different groups have filed in the past. I think it's definitely possible. If you want to, again, as Liza said, give enough information that they can really look into it. So you might want to do it as a group, and then also give enough information that they can look at. They're still going to have to look at IEPs and other things for each individual child. But it can be, you could also have, so you could file as a group. You could also have each person file an individual complaint and send it together and make it clear that this is a systemic issue. One thing that Liza's done a lot of great work with the state is looking at where there's some issues that really are more systemic, that are not just impacting one child. And the state does have the state, in order to comply with special ed law, is supposed to be trying to identify circumstances where there's some non-compliance that might be impacting more than one child. And so they really do have an obligation to look at problems that might be impacting more than one child and giving help and relief for a class of children or a group of children. So Liza, you've had some experience with that. I don't know if you want to add in there.
Yeah, I agree with everything that you said. I think, you could file as a group. I also think it would be very powerful for you to file a whole bunch of individual complaints, because then the PRS system has, kind of more complaints to their system on the same issue about the same district. And in some ways, I think that can be more powerful, just the sheer number of complaints that they're getting, because they do pay attention to, as Julia was saying, systemic issues. And I think that a lot of times that can almost be best captured by receiving a large number of complaints regarding the same district on the same issue. And then, as Julia was saying, the PRS has issued some letters of finding in which they've actually acknowledged in the letter of finding itself that there have been systemic issues in this particular district around this particular issue, and have even referenced other complaints that have been filed. And so that's kind of the best case scenario where DESE has, PRS system has acknowledged that there's a systemic issue that needs to be remedied. And that's going to make it more likely that PRS is going to issue corrective action orders that are systemic in nature, and really, as Julia was saying, ordering the district to make kind of broader, more sweeping district-wide changes, as opposed to just simply addressing the non-compliance in the individual student's case. So I think, you could file it as a group, but it also could be equally powerful to file a whole bunch individually.
Thank you. Our next question is, I have recently received a COVID compensatory services agreement where one part reads as follows. Parent/guardian of the student agrees to release X district from any and all claims for compensatory services or damages which she, he, or student may have or assert against the city and X district for the 2019-2020 school year through the date this contract agreement is last signed below. Are school districts allowed to ask parents or guardians to waive their procedural rights?
We're looking at, we don't want to talk over each other, so neither of us are talking, sorry. It's a really good question. We're seeing that more and more frequently, that districts are asking parents to sign those kinds of waivers. So districts can ask parents what they want to ask them, but a child's receipt of compensatory services should not be dependent on a parent waiving their rights, especially waiving them beyond their right to compensatory services. So I guess there's two choices for you as a family. You could say, I agree, this is the amount of compensatory services that my child's entitled to. maybe you agree that it's everything your child needs for last school year, but you don't agree that they've provided everything they should for this school year. You know, so maybe you would want to say in the agreement, I'll waive any rights I have for last school year, but I don't agree with you yet that this is all that I need for this current school year. Some of the things that we've seen parents being asked to sign, they're asked to waive not just their right to compensatory services, but the right to raise anything against the school district. And that's really very clearly overbroad. They should not, and that's not fair to put a parent in the position of having to waive their rights. You know, what if you find out that there was something not even related to special ed, but lead in the pipes? You know, you shouldn't have to wait that were, you know, sadly unhealthy for your child to be drinking, assuming they were in school, but some kids were. So it shouldn't be overbroad. It shouldn't be asking you to waive things that are not even related to compensatory services. And I don't think it's what was ever intended when the state issued this guidance, that there would be these kind of broad legal kind of waivers. And it's really confusing for families to see them. And a lot of the ones we've seen are very overbroad, asking parents to waive their rights way beyond anything to do with compensatory services. So our advice would be is if you're not sure, you can ask questions of the district, you can call our helpline, you can call some of the other advocates, because I think, you know, all of us are seeing these enough that we'd be able to look at the language. I'm more of a visual than an oral person myself in terms of reading it. Liza, do you have anything to want to add?
I agree with all of that. This is something we're definitely seeing. And as Julia said, a lot of the clauses in the agreements are even more broad than waiving rights to compensatory services. It's waiving your right to a free, appropriate public education, which is not something that we would really ever advise a client to sign if they're just trying to resolve a dispute around a narrow issue of compensatory services. So I would just make sure with those agreements that you're reading them really carefully, and yeah, calling our helpline if there's something that you don't understand, or seeking the advice of an attorney, because those clauses can be kind of snuck into these agreements. And oftentimes these agreements are kind of boilerplates that districts use. And you just want to be really careful to make sure that you're not waiving claims that you don't need to be waiving.
And again, it's not what the state ever, I believe, you know, in all their guidance, they're anticipating that these are IEP team decisions. And when you have an IEP team agreement, there's no waiving of rights involved. So it's really troubling that districts are doing this, to us anyways.
Absolutely.
That's a good question. Does the IEP team have to consider the impact of COVID on initial eligibility for special education? For example, a child with autism on a 504 who's regressed socially and is experiencing more anxiety due to COVID and now really needs more support than a 504 can give. Can the school say it's just a temporary lack of progress due to COVID, so it's not enough for eligibility?
The state has made it very clear that when teams convene, they should look at you know, where the child is currently, whether or not the child may or may not need compensatory services, and as this family is asking about whether or not there may be new needs that the child has, you know, particularly as a result of the pandemic, requiring additional, you know, maybe they need an IEP when they didn't have an IEP before. Maybe if they had an IEP, they now have, as a result of the trauma they may have experienced because of the pandemic, they may have some additional mental health issues or other issues requiring additional services in the IEP. So it's really clear from the law, it's really clear from the guidance from the state that when the 504 team or IEP team reconvenes, they should consider, I believe as this family was asking, whether or not there's some new needs related to the individual's disability that may require different services, or in this case, an IEP instead of a 504 plan. So it's absolutely the kind of thing that the 504 team and the IEP team should be considering, at least in my view. Liza, what would you want to add to that?
Yeah, I completely agree. I think that lack of progress and needs that have arisen during COVID are absolutely relevant to the determination of eligibility discussion, and shouldn't be this district should not be responding by saying, well, those are just temporary. They should be carefully considering them and making the determinations. I just completely agree with everything you said, Julia.
Okay, we're just past 8:45 if you want to pop up the question.
Right, so we will stay on until 9, but we know some people need to leave at this point. Liza, do we want to invite people if they have any, at the last chat last month, we asked people for any ideas that you want to share about what topics you would like us to cover next month. And a lot of folks asked to talk about PRS, which is why that's the focus tonight. So if you have any ideas, particularly as you're thinking about summer, I'm surprised there's no questions about summer, and then school reopening in the fall, you know, any topic that you think might be helpful, just share your thoughts in the, I don't want to say the chat, in the Q&A. Is that where you want them, Lilia?
Yep, you can put them in there.
And in the meantime, we have this evaluation poll just to give us feedback on how you know, this was for you.
Thank you. And you will be directed to the survey also when you close out, so please be sure to fill that out. Thank you. We do have a question about summer. My children's district has decided to offer a general education program over the summer that's by invitation only. My children qualify for extended school year but have not been invited to participate in the general education summer program. Would this be considered an example of a school district creating a restrictive environment that prevents inclusion and therefore evidence of a civil rights violation? The Director of Student Services was alerted to the potential of this happening before the program was announced and invitations were extended to general education students. What remedies, if any, might be available?
I'm a little confused about a gen ed, what that means by invitation only. I mean, before COVID, I know there were some kinds of summer programs that schools would run that would be for gen ed, but would not be open for all gen ed students, but might be open for gen ed students who were struggling in specific areas or at risk of not being promoted. So I guess it depends. Whatever the criteria are for the gen ed program, it needs to be applied equally to students who have disabilities. You know, so if the gen ed program is saying we're only going to offer the program to children who don't have IEPs or don't have 504 plans, that to me sounds like a very potentially clear violation of the federal civil rights laws. The state's been very clear that these, especially with there's a lot of federal money going into summer programs this year, and that the districts need to provide accommodations and modifications so that those gen ed summer programs will be open to students with disabilities as well. So I guess it's hard to answer without knowing what it means by invitation only. But whatever the invitation is, it can't exclude students with disabilities in a discriminatory way. Liza, do you have anything to add there?
No, I agree. I mean, hasn't there been guidance from DESE that for regular ed summer programs that are offered, they have to also be offered to students with disabilities, making the appropriate accommodations? I mean, I agree. I'm not sure what's meant by the invitation only, but if it's just a regular ed program and regular ed students were invited, then students with disabilities need to be invited too and be provided the accommodations that they need to access it.
And there's a lot of confusion for a lot of people about summer programs, because you have some students who have summer programs, the extended school year in their IEP. You have some students who are getting summer programs as compensatory services. You have then you have many more gen ed summer programs being provided than usually there are, that should be accessible and accommodating students with disabilities. And you also have these exciting opportunities, the way this person said, where typically students with disabilities over the summer don't have inclusive options. So the state is really encouraging districts to do exactly what this person is asking about, is to look at ways to provide more inclusive options for students with disabilities. So again, this person could call our helpline so we can get more information, but it's a really important issue that they're raising.
Thank you. I just dropped a link to a chat we had a little while back on inclusive opportunities during COVID with a special education teacher. Can you please clarify if there's a difference between remedies for services on an IEP that were not provided versus services being provided remotely, but the child wasn't able to access them? In cases where the services were written in the IEP, but they weren't provided, is the remedy based on hours missed while services were provided but not accessed, based on level of skills lost or not attained?
I'm smiling because I got the first half, but not the second half. Liza, do you want to start with that one?
Yeah, it's a really good question. So basically my understanding of the question is that what is the remedy when when the service was delivered, but the student couldn't access the service? You know, what might the remedy look like? And is it just the number of service hours that were delivered, or is it also tied to lack of progress or skill regression? And I would say, as with any determination around a COVID-19 compensatory services, it's kind of the combination of a service that either wasn't delivered or couldn't be accessed, and also looking at the impact on the child. So whether the extent to which the student was not able to make progress, lack of progress, or if the student has actually regressed in their skills. So regardless of whether the service wasn't delivered or it was delivered and couldn't be accessed by the child due to their disability, either way, you're definitely in a complaint going to want to address the second kind of prong, which is how did this impact the child? What was the effect on progress? How were they not able to make progress as a result of not being able to access the instruction? So if there was, you know, speech therapy delivered remotely, and the child, say the child has autism and a lot of behavioral challenges, and was just running around the house and was just not sitting at the computer and just couldn't access it at all, you would want to explain that in the complaint. You know, they couldn't access it, and here are the examples of what was happening during that session. It may be behavioral, or there could be some other reason they weren't accessing it. And then you would want to go a step further to say, and this was the impact. You know, they used to be able to communicate X, Y, and Z, and now they're no longer able to communicate that. Or they, you know, they have X, Y, and Z goals and objectives on their IEP, and they haven't made any progress on those related to speech. And then in terms of what the actual remedy is, it's not a perfect science. So it's not necessarily, as Julia said earlier, the exact number of sessions that were delivered that the student couldn't access, but more what's going to make the student whole based on the difficulty accessing the service combined with whatever the impact was on the child. And that determination is, again, it's more of an art than a science. And it's going to be really helpful for you to weigh in about what you think your child will need in order to begin to make progress again in speech, or to make up some of those skills. And I think, as Julia mentioned earlier, also consulting with any outside evaluators that you may have, or pediatrician, or someone who might be able to weigh in about what an appropriate remedy might be. Julia?
Yep, that sounds great.
Next question. If I had to sign an SELP, Special Education Learning Plan, instead of following the entire IEP for services due to COVID, that's what the district said, is this a PRS issue?
There have been different documents for last year and this year that districts, if an IEP was going to be implemented differently, then the district was required to provide a special education learning plan, or there's different things that it might be called, but the district was required to inform a parent that the IEP would still be fully implemented, but it might be implemented differently if the child was going to be, you know, full-time remote, or services might even if the child's in school, they might need to get their therapies different if the speech therapist can't go around to each of the different classrooms. But it was never something that had to be signed, because the IEP was what's still controlled, and the IEP still had to be fully implemented regardless. So the special learning plans and the other kinds of learning plans were only informing the parent about how the IEP would be fully implemented, but implemented differently, or what the schedule would be that might be different. So it's a little confusing. If the district was telling you had to sign it and you were therefore kind of giving up what was in the IEP, that's, at least to me, sounds clearly non-compliant. The one thing that I keep thinking about and then forgetting to emphasize, but I think probably most of families are doing this automatically, is, as we know, teachers, administrators have been working really hard. I mean, this has been an amazingly difficult 14 months for everybody. And so what we find, even when we're, representing as lawyers or advocates the families we're working with, it depends on how urgent the situation is, but we will usually first write to the special ed director, let them know about the problem, say, if we don't get a response, we're going to be, filing this complaint in whatever, 2 weeks, 3 weeks. And sometimes that will help you to get it resolved locally. It's always worth trying. I mean, it's not always worth it. You'll know in terms of your own child whether it's worth that, but sometimes that's a faster way to get a remedy. Sounds like a lot of you have really been trying to get things worked out locally. And so in that case, you may just want to go right to the complaint. But we have seen things get resolved just by letting them know that a complaint will be filed by a date certain if things aren't worked out. Do we have time for one more question too? I don't know what time it is exactly, Lilia.
Yeah, let's do a couple more. Next one is, my district had a tiered focused monitoring and the report was supposed to be available in March. Do you know how to find where this report might be if the school has not released it yet?
They are posted on the state's website. I don't know exactly what the link is, but they're not that hard to find on the website. Again, if somebody wanted to email our helpline, we could.
Oh, Joanne just posted it in the chat, I believe. Joanne just posted it in the chat, so there it is. Thank you, Joanne.
Boy, is she good.
That was very quick.
Okay, hold on.
And what should people do if they have questions that they didn't get answered? Should they email our helpline or call our helpline, William?
Yeah, call our helpline or fill out the helpline form on our website. I'll drop that in the chat one more time. Also, if you follow us on social media, then we might answer some of your questions through our posts there. And if you join our Facebook group, then you can continue the conversation in the Facebook group as well. So I'll share all that in the chat. Our last question is, how can a parent demonstrate the student's inability to successfully participate in remote instruction when the district asserts that full participation based on the fact that the student was logged in?
It's a really good question. We've had, I think Liza mentioned this, we've had families who take videos with their phone to show what's actually going on with the child, or otherwise take notes in real time, send emails explaining what's happening, once a week or frequently, so that there's some paper trail to, really describe what's going on with the child. I mean, that's why the state has said so clearly that these decisions about how a child's accessing learning really have to rely on the families, because it's the families who've been the parent and teacher and speech therapist, for all these months. So those are the kinds of things that can be really helpful. It's also not supposed to be just being logged in. There's supposed to be live instruction being provided for students who are learning remotely, so that there needs to be some interaction. So the teacher should be not just seeing that the child's logged in, but actually engaging with them enough to have a sense of how they are participating. But we know that that is not always happening. Liza, do you have anything to add to that?
No, and I would just recommend, taking careful notes somehow on how your child is engaging with remote learning. what kind of progress they're making, challenges and barriers that you've noticed. Just keep a running log. We have an app to help you track remote learning and how your child is doing. So you could use that, but you could also just use a pad of paper and just write the date and whatever the class or the service was and how your child is doing and any barriers they were having, and just jot down specific examples of what you think the barriers were for your child accessing the session. And I think, you know, that's something that you could later raise in a team meeting, you could raise in a complaint, you could raise those examples.
Yeah. And I think those are great ideas. And you can just send a text, however you're communicating with somebody in your team, you can send an email that day, say, this was really a hard day. I couldn't get them to sit down and, you know, participate. And, you know, every time you've got the time or bandwidth to do that, that's helping them to really understand what's going on. And also, like Liza was saying, it gives you a paper trail of what's been going on to show.
Definitely, yeah.
Great. Well, thanks all of you who've hung in so long. We know it's really long and late on Thursday night. It's an amazing, dedicated group of parents and advocates who come to these chats. And you always ask great questions.
Really good, really good questions. And thank you all so much for coming. And we look forward to seeing you again at another chat soon.
Don't forget to give us your ideas for the next chat.
Yeah, we're getting some great ideas too. So I'm going to leave this open for just a second longer so you guys can send us your ideas for future chat topics. And do fill out that survey once you X out. Thanks. All right, good night, everyone.
Good night.